Hello, I'm Jessica Mills, and I'm here today with Dr. John Chesterman, Manager of Policy and Education at the Office of the Public Advocate, to discuss the new Powers of Attorney Act, which commenced on 1 September. So, John, what are some of the changes that practitioners need to be aware of under the new Powers of Attorney Act?
Thanks, Jessica. The new Powers of Attorney Act, which comes into force on the 1st of September, essentially brings together and reformulates the law concerning the general power of attorney, now called a general non-enduring power of attorney, the enduring power of attorney financial, and the enduring power of guardianship. And the key change is that from the 1st of September, it will be possible for a person, now called a principal, on the one form to appoint one or more attorneys to make decisions on the principal's behalf in relation to financial and or personal matters. And personal matters are defined to include lifestyle type decisions, such as where a person lives and consenting to medical treatment. The appointed attorney or attorneys will be able to exercise their powers at a time chosen by the principal. That could be on the moment of execution, or it could be at a later date when, for instance, the principal loses the ability to make particular decisions. One very important point to note about the new legislation is that it does not affect the operation of the enduring power of attorney medical treatment. That continues to operate alongside this new legislation. There are a number of safeguards introduced by the Powers of Attorney Act 2014, including the creation of some new offences. The Act also sets out principles to guide attorneys, as well as articulating the duties that attorneys have.
Okay. Now, the Act also introduces a new supportive attorney. What is a supportive attorney?
Well, that is indeed a new creation in Australian law, and it really marks an Australian first foray into the important human rights field of supported decision making, and that modern push for the recognition that people should be supported to make their own decisions rather than have decisions made for them owes much to the United Nations Convention on the Rights of Persons with Disabilities. So, as you say, there's a new category of appointment called supportive attorneys made possible under the Powers of Attorney Act of 2014. So from the 1st of September, what that means is supportive attorneys are able to assist a principal to make decisions by collecting relevant information, communicating information, and putting decisions into effect. The important thing to note about the appointment of supportive attorneys is that when they assist the principal to make decisions, the decisions are still those of the principal. They are merely assisting the principal to make decisions. It's important also to note there's a safeguard there which holds that supportive attorneys, in putting a principal's decision into effect, cannot do that in relation to significant financial transactions.
Are there any change to witnessing requirements?
Yes, there are. In relation to the enduring power of attorney for financial and or personal matters, there are elevated witnessing requirements. So from the 1st of September, with those new powers of attorney, one of the two witnesses must be either a doctor or able to witness affidavits. For the supportive attorney appointments, one of the two witnesses must be able to take statutory declarations.
Okay. And now what about current powers of attorney? Are they still valid under the new Act?
Yes, that's one of the big concerns that people will have. The short answer is yes, they are.
Okay. For more information and to find the new forms, what should practitioners do?
The new forms, which can be completed online, will be available on the Office of the Public Advocate's website from the 1st of September. So people can complete those online. They still need to be printed and signed and appropriately witnessed.
Thank you very much for your time today, John.
It's been a pleasure.